Good morning to everyone. So, behalf of IIC SVC Sri Permudu, we welcome you all for this workshop on intellectual property rights and IP management for startup. Now, I request Mr. Vignesh from Chemical Department, final year chemical, to introduce our speaker. Please, Vignesh.
Thank you, sir. Mr. M. Nishal did his undergraduate studies in mechanical engineering from Anna University. He did his postgraduate studies in manufacturing systems engineering from Coventry University, UK. He has a teaching experience of 9 years and he has published 10 international journals and 6 book chapters in the areas of supply chain management, and Industry 4.0. His patent filed on prosthetic arm has been granted recently from IPR, and another patent has been granted for biodegradable plastics. On behalf of IIC SPC Sri Perumbudur, I would like to invite Mr. M. Nishal, Assistant Professor, Department of Mechanical Engineering, to deliver his lecture on intellectual property rights and IP management. I welcome you, sir.
Thank you, Vignesh. Uh, is my PPT is visible?
Yes, sir. But we'll make go slideshow, sir.
Yes, sir. Is this okay, sir?
Yes, sir. Yes, sir.
Okay, sir. Thank you. So, good morning, students, everyone. So, welcome you for this IPR session. So, in this session, we're gonna go through a roadmap stating what is IPR and what are the different IPRs we have to look into it, and how it is being enhanced from a different perspective of design aspect, industrial aspects, and all. So we'll go through few more examples also. So let's get into it. So first, we have to know the importance of intellectual property rights. So as you know, protection of the rights of the intellectual property generated by intellect is an important thing because it's not about like spending your entire time for inventing, but also to ensure there is some adequate returns and to the investment which we have made. So that is one of the key things. So it has become important for the technological and industrial economical development of a country. So we will even also look at the second point. The second point is quite an important aspect because like our country is standing and at what level we are standing. So we'll see one by one each. So industrial property and copyright. So industrial property consists of mainly of patents, designs, and trademarks. So these things are a set of a segment. If I look at a copyright, that is entirely regards to an artistic creation. It could be a poem, a novel, a music, what songs which you are hearing, painting. So especially like software like Facebook, Twitter, and all those things where we can see at the very last line, C symbol will be placed. So that is more like stating copyright. So intellectual property is a property created by a person or a person using his or her own intellect for ultimate use in the commerce. So in this, it could be any aspect. It could be of any set of an invention. So when you are talking about inventions, anything new or a new process, a new way of thinking, which we are able to uh, do a better process or better product or better service, which will enable us look as a intellectual property. So examples of a few IPR inventions relating to a product or process or a new design of an article, a literature, artistic work, a trademark, which could be a word, symbol, or logo, etc. So these are a few examples. In detail, you'll see for each and every one how these products is being as an example, because the IP is uh, which is indirectly uh, puts our country at the place of in the place of developed countries because IP increases which equals to more product being introduced into the market. That is stating our GDP growth will be directly in relation with to these new product developments and intellectual properties. Right. So, what does intellectual property means? A property which is tangible and intangible. So, tangible is which we could measure up. Say like a movable car. If it is immovable, like a building, it is tangible. He will be able to uh, identify the physical consistency of it. Whatever it is intangible is an intellectual property. So, which is going to be something industry property related or copyright related. So, if it is industry, the other four things is going to come like patents. It could be a product which is patented by the company. It could be a design. Design is something, futurist designs which can be patented. Say, for example, prototype cars are coming during a car show and all. There will be more designs which are being patented in behalf itself. So, future trends mostly like. So trademarks are something which symbolizes uh, the origin of the product or symbolizes the product identification, which we could identify from the specific design or a word, state that this is the product which we are looking for. And GIS is nothing but uh, which is going to be of a geographical IPRs that is based on the geographic situations. Like, for example, we could always say that whenever I state about Tirupati means everyone gets to know about that. So that is like a geographical IPR. So these are the five things which is quite ultimately comes to play a lot. So if I talk about patents, designs, trademark, say if I say talk about any car company, whenever we see a symbol on the car, which will definitely gives an idea. Okay, this brand goes to this particular company, which is known as a design or trademark. Say, for example, you go for a Maruti Suzuki, you see a S symbol, that's a trademark symbol. Hyundai, it's a trademark symbol. So if I say Cadence, it's a trademark symbol. Adidas, Nike. So many companies are there. Even IT companies, TCS, TTS, even everyone has one particular set of a symbol, which is a trademark design. It's not, it doesn't come under exactly design because these are particular words or an emblem or some design which symbolizes their company or their set of a product. So that is trademark. So intellectual property is like of five different things, IPR. So one is design. So usually we call it as an industrial design because it is going to be a process or a product design which is being done. So it is called as industrial design. So one is trademark, patents, copyrights, and geographical indication. So exclusive rights given to a person over the creation of their minds for certain period of time. So that is stating that it is giving a exclusive right that when you have done a product or produced a product, you just can't own the idea or the product itself. So what you have to do is we have to file an IPR based on the whether it's a design or a product so that we get the exclusive right for it. So we can have a legal right. So it becomes as an intangible potential asset, a monopoly. So negative rights is that is it prevents others to use his or her name for a definite time. So that is I can avoid other companies to create such kind of a product within the country because without the our designs or our products exactly same cannot be replicated. So it gives us a sense of purpose or a sense of uh, a positive hope so that we are covered by that. So that is an important thing what IPR. So IPR given by the government right now, it's a quite the important one, right? So these are essentially recognized and are accepted all over the world due to some very important reasons. It is to provide an incentive to individuals because someone is creating something new. Obviously, it is be looked as a product for marketing in the real world. So the incentive, the official could be say the WhatsApp recently it has been acquired by Google. So WhatsApp was a separate company which was created by a separate guy. On the downright, it was patented. It has copyrights in it. So what Google has done is to acquire that they have done. an incentive to that particular individual so that they acquire that particular product. It's just an example. So without that IPR, if I launch any product or any uh, designs or any set of services, it will be quite the wrong path without an IPR because I cannot have a legal status stating that I own this product, I own this design. So this is why IPR is quietly recognized by everyone to accord due recognition to the creators and inventors. So there are two set of things because in a company, inventors will be there, but the patent will be filed on the company's name. So if you see any IPR forms, there will be a state that who's on whose name the patent is going to be filed and who are the inventors. So in the inventors, even the you work for a company, the patent is filed on the company's name. As an inventor, you will be benefited out of it. So to ensure material reward for intellectual property. So material reward is like uh, how to trade up your intellectual property rights for a reward status. So to make it available, genuine and original product. So we often we would have heard like a second copy or a first copy of any product. That is stating that they cannot directly sell those copies in the market without any legal issues. Or stating that they are the original products, they cannot sell that. They can sell it as a direct first copy. So that is the main availability of IPS. So what are the various kinds of IPS we have to see? So as we said, like we have patents, we have designs, we have trademarks, we have geographical indications and copyrights. So what are these five base things they have created is? So if I talk about patents, it's kind of a complete product or a process or a materials and composition. Say for example, I say products. It could be anything. Say for example, I'm going to develop some new product for a car, which is going to be a sensor. Means it's a new product development, right? So if you talk about in the olden days, we don't have a kettle and all. So it is a new product. So mosquito bat is a new product. So these are the new products which has been developed. So if I talk about processes, means processes either could be within the industry to develop a product, or it could be stating as a services. Say for example, urban cloud. So those set of activities are all Uber. So these set of activities which has created as a different set of a process to serve the people. So those are processes which could be identified, or even I can state that how to create a process for refining a material or a raw material to be refined so that I appear a different set of a raw material. So that is a different set of a process. Then we're going to see materials. Material is something like a different set of a combination we are seeing right now. Say, for example, in the olden days, car bumpers would be made up of strong iron. And all. Right now, we are using flexible materials over there. So it is like a composite material so that it doesn't get broken up. So it can do get back its original shape and it's pretty cheap also. So those are the things like inventions we can talk about. Then technical solution to a technical problem, how to address those set of a problem. So that those are the things which we are, could be called as patterns. Then we're going to see some industrial designs. So design is basically a thing where you don't pattern up your entire design. That is stating its entire composition, like what is what, which part is, what kind of a role the entire design is going to play. Every aspect of the design document will be submitted, which can be an external features appealing to the eye, or a new shape, a pattern, or a configuration also it could be. So if I say new shape, uh, everyone would have seen a tennis racket, right? So tennis racket is entirely of a different oval shape and all. So that could be patented by some companies, right? So a pattern or a configuration could be at the same method. Say, for example, I'm gonna create a design for locks, because lock is obviously gonna contain of a spring, gear systems, which is comprised within a lock. But if I'm going to use in a different manner, only the design part can be uh, patented or given a design IPR. because I cannot go and state like I've developed a gear in that perspective. So these are the new ways where you can just uh, get your designs patented over there, so that your designs could not be used by other companies. So trademark is something a visual symbol, as you said, which could be a name or a word or a logo or label, also a monogram, a
Sir,
slogan.
sir,
Yes,
excuse me, sir. Sir, slide,
yes, sir.
you're changing the slide, sir. First slide. Now it is visible, sir. Okay, sir.
I'm sorry, sir, because I
Uh,
think my uh,
yes, sir. Now it
slide
is
is not
visible, sir.
moving.
Yes, sir. Yes, sir. Okay, sir.
Okay.
No.
So when I talk about monograms or slogans are applied on article of manufacturer or services, which is going to indicate directly towards that particular product. So that product is being identified through a design or a particular word. So that is very key important as a trademark because like in the marketing conditions, we can see only a without with just the name, it is impossible for us to get into the market. So if I start to look on designs, which could indicate the origin of the goods and the services, it will be very effective for us. So trademarks of those designs. Say for example, even a Facebook, if you can say that F is a symbol for that, say Twitter T is a symbol. So if you take any car company, every car company will have a logo. Every car company will have a name for that, so that they can be easily identified with the help of that such kind of a design symbol. Say, for example, Adidas, Nike showrooms, or Reebok, those are easy designs which we are already embedded into our mind. So currently, you guys will be using Swiggy or Ola. So you can state that. So these kind of trade symbols are quite important so that it puts your space into the market. Take any startup, take any company, which will have a unique name and a unique logo because you need to stand out in the particular market. That is quite necessary. So next, you're gonna see is copyright. Copyright is something like artistic, literacy, musical, dramatic creations and all, such as movies and all. Then proprietary rights, which comes into existence as soon as the work is being created. So whenever a movie is taken, always you look over there, it will be stated as a copyrighted. If you take any websites, you can see that at the end of the line, it will be stating as a copyright. Even if you take the SVCU, in our SVCU website also, there will be a copyright conditions of that. That is stating that they have copyrighted but these designs over there. So that is states that what is a copyright. Right? So these are the various types of IPS. So there are really five types of IPS. So the next one is geographical indications. So, so the geographical indications are like which identifies agricultural or natural or manufactured goods originating from a definite territory in India, uh, stating that it possessing a special quality or reputation based upon unique characteristics of the geographical locations. So when you talk about geographical indications, there are a lot of things like Tirupati Laddu, as you said before. Everyone knows about Tirunelveli's Alva. So I think these are the uh, things which is fixed upon the geographical indications. I can't use the same set of words or a name or a trade logo for a product which is being done in somewhere else. So geographical indications is quite a necessary one. Uh, I'm sorry if anyone is pinging me. I'm not quite sure. No. So, uh,
Sir,
oh, yes, sir.
anything you want, sir?
No, sir. No, sir. I thought
Oh,
some
okay.
pinging going.
Okay, sir. Okay.
I think, guys, my PPT is not working properly. So, can I go in this mode itself, sir? Uh, because when I change it in the play mode, it gets stuck, I guess.
Yes, sir. Now it is visible, sir. Now you are changing everything. Yes, sir. Now it is
Okay,
visible,
I'll
sir.
change it one by one. Let me come back and now. So
Okay,
that's
sir.
those are the things which is basic. So what is the organization structure of our IPR in India? It's like a Ministry of Commerce and Industry, which is comes under for Department of Industrial Policy and Promotion. So Ministry of Commerce is the one which is gonna take into control of the entire organization structure of the IPRs over here. So from the Ministry of Commerce, the Controller General of Patents, Designs and Trademarks is being proceeded with that. So under there are like a patent office, trademark registry office, geographical indicator registry, and patent information systems. So if you see, these are the set of uh, patent and design officers in India. Since we are in Chennai, we would have seen like a few patents we're gonna go and file it. So we are in Chennai, it is easy for us. But if you're coming from other cities and all, either you have to do it online or you can come directly and submit the forms to set of the officers so that it is easily processed. So the trademark registry is which is placed in extra in Ahmedabad. So geographical indications registry is in Chennai itself, and pattern information systems is one is in Nagpur. Uh, so the other one is like RGN 2 p.m. So when you are talking about the organization structure, it is pretty simple to look around. But the important thing is these are the offices. But when you see in forms like and all, it is going to be like nearly 4 to 5 forms which you have to submit when you are filing a patent, and all, right? So why do I do a patent is like so when I if you see the number one, patent is like maximum protection year for a product which is given as 20 years. So every year mandatorily we have to renew the product so that it is being in live patent, because like when I granted a patent every year I have to renew, or else it goes as into a disposal or stating that it is being voided, so that any other companies could come and use my patent over there. So if I go for trademark is a design product. So we say like it's going to be a logo or a name or a word, right? So which is going to be lifelong. So they expect the renewal to be after 10 years, right? So the Trademark Act has been implemented from 1999 and amended in 2010. So if you see the design pattern, its maximum protection is 15 years. So after 10 years, uh, it can be renewed up for next 5 years. Because why design is being given a lesser number of years is, as we have seen, like continuously every product's design changes is going to happen at a very higher rate. So even 15 years we state that, but that design might not be in market at all in those 15 years itself, right? So next is the copyright. So copyright is something quite an important thing, because when I put in a website or any other uh, uh, movies or any kind of a box stuff with artistic works or a painting stuffs like that, which will be given 60 years. It doesn't need a does not require renewal at all. So copyright is something which is the max protection 60 years from the age of the inventor. So whenever an inventor is going to post it up, either they're going to be over there or not, it is going to be there for the next 60 years. So next is the geographical indication, which is lifelong. So every after 10 years. So say for example, some of you would have been coming from Kanjipuram. So Kanjipuram Pattu, that name cannot be used uh, in any other places, because that is all as a geographical indication, right? So patents will cease and be transferred to the public domain if the patents are not renewed within the 6 months of expiry of the concerned year by paying the renewal fee. So this is what we have to see as a inventor or entrepreneurship when you patent up your product, and when it is come to a market, at least nearly 5 years we have to patent it up, or that is we have to renew the pieces or not, so that our product is not used by our competitors. So that is quite important one, because it is the exclusive right of the inventor to prevent others from possessing, using, or selling, manufacturing our products. That is stating that they cannot import the patented invention or offering to do any of these within a definite geographical space. That is like if a patent in India, in India, that particular product which you have patented cannot be used by others. Because patents always have a territorial jurisdiction. We have to register patent in different places, that is in different countries where we have our interest. That is, we are going to do our production or marketing in other countries. We have to put our patent in that places. So patent applications can be filed in India by investor or is assigned. So is assigned means someone on his behalf can do it on www.ipindia.nic.in. So these are the things which we have to keep in mind while filing an IPR, right? So a patent is something like a monopoly. A monopoly is something uh, right which is granted by the government of India itself. So a monopoly is something one who owns the entire patent itself. So which is granted by the government. Uh, it could be given for an invention or to the inventor or risk assignee as a territorial right in lieu of disclosure of the invention to the government. So term of the patent is, as we say from the last slide, that is 20 years from the date of filing. So that is a key thing what we have to see. So the next thing is, quite importantly, the criteria of patentability is quite importantly we have to see seen. So what is the criteria is, it should be novelty. So novelty, what is novelty is like whether it is being unique, so whether it is not inside the market, which is of a genuine invention done by one particular person or not. So next is like whether it's an inventive step or it must be non-obvious. Non-obvious means one should not think it is obvious. So it should be stated as a non-obvious one and capable of industrial applications. Capable of industrial applications is like whether it is being properly used in an industrial aspect or not, or it's a patent which is of no use at all. So these three things is quite necessary one. If you see the fourth point, not to fall within the provisions of Section 3 and 4 of the Patent Act 1970. In 1970, they have stated that Section 3 and Section 4, where we are one person who is going to patent a product or his design or his trademark or copyright or geographical indicator should not fall under the section of 3 and 4. So that is quite important because Section 3 and 4 states more uh, points which we need to look around when we are going to do a filing. So that is quite importantly it has to be seen, right? So yeah. So as per the Patents Act 1970, Section 3 lists which are not inventions, which is frivolous or obvious. So obviously stating that I cannot develop a product which is obvious of just by assembling some other different products to create a product. So that is stating that obvious. Contrary to well-established natural laws, because one particular problem came to us was Germany was about to patent the turmeric, which we have been using for quite a long centuries we have. So that is an important one. So that is stating that those natural laws cannot be patented. So with patents or products which is injurious to public health. So public health is quite important one which is being taken care. So they directly they will see that whether your product is injurious to public health or not. So as we said, like a mere arrangement or rearrangement of a process or a product cannot be patented. Discovery of scientific principles. Scientific principles is nothing but the natural laws which is already in place, which is there in the natural set of law, cannot be given as a patent. Discovery of a living thing or non-living substances in nature. And so method of agriculture or horticulture, mathematical or a business method or a computer program. A computer program cannot be patented, but it could get the copyright. So that is the thing what we are thinking. The last is in the mathematical or a business method or a computer program. We could get a copyright, but the copyright states that precisely what you have written only could be copyrighted. Any kind of changes or small modifications could lead to a different copyright. So that's the thing which we have to see it enough. So that is quite important. So these are the section 3. If you see the section 4 is not patentable because something which is related to atomic energy related cannot be patented. It will be taken up by the government itself, and certain necessities will be given, or any deals with the government should be done. So I hope everyone can state that what could be patented, how it could be patented, and what are the things cannot be patented is a quite important thing as a young engineer, because your wider views are there. So you see the entire place in a different perspective rather than from the adults one. So when you see that, you see a product, which how it could be used. So when you think in that perspective, you have to keep in mind these set of points so that when you're going to go put a patent of or do an IPR for any product or a process, these set of points will be very helpful for you. Right. So next, what you're going to see is relations between the IPR. So this is everyone knows about Coca-Cola, right? So we have taken that same example because if you see in Coca-Cola, Coca-Cola is an example of trademark. So the word, the name, how it is written, it's a trademark example. The shape of the bottle is an industrial design, so no one could use the same shape of the bottle itself. If you have seen in the market also, you would have bought some drinks, you would have had some drinks, but no brand will use the same bottle shape or size also. They will have entirely different things because it is an intentional design where how it is being holded up. So there are a lot of aspects in a bottle. It is not just in a water bottle because there's going to be a drink. They handle those designs so that they cannot use that particular shape of the bottle by others. Because if you see in this particular one, the design of the bottle is ratio wise patented. That is, if I bring the ratio up, I can scale the size from the original to the much higher or the lower also. But the design cannot be taken up by the other products or the other competitors companies. So patent may be been obtained in the respect of bottling equipment. So copyright in respect of the text, database or artistic work appearing on its website. That is, a single product can be protected by more than one IPR. That is what they are stating here. So that is what we have to look at. So Coca-Cola company comes in and it just it's not patenting of a product which is kept inside the bottle. So uh, how it is bottling, those equipments can be patented, and the shape of the bottle, then the trademark, that is the name, the how it is written, the copyright for writing the fonts and all, those things can be patented also, so that in a product, so that it is entirely it is not replicated by its competitors. So this is one good example for different IPRs and all. So if I'm going to look into the other IPRs, so if you see this, a patent means a product. So a product is like it could be a fan or a mobile phone. The entire mobile phone could be there. So if you see the Apple logo and all, it's a trademark. So it's like Apple which is being written off. So that's a trademark symbol, right? So if you see the geographical indications, the Tirupati letter as you said, so that is an geographical indication which cannot be used by others. Also. So if you see as we discussed in the Coca-Cola, the trade secret, trademark, industrial design, and the patent is given. Another one is uh, Kolpuri Chakra. That is also a geographical indicator, so that the name or the product cannot be used by others. So that is a quite important one, which we have to look into it. Right? Right. So the next set of examples are the industrial design. So exclusive rights against unauthorized copies could be eliminated from this. Protection normally lasts for an initial 10 years, then which can be renewed, and most cases it goes up to 50 years. That is, industrial design is like could be a jewelry. Well, right now we are seeing most of the jewelry, right? Uh, yeah, I think your parents would have gone to a jewelry shop, you would have accompanied them, So if you see whatever products available in one set of companies will not exist in the other. That is for special designs. We are talking about designs, right? So a company of different companies will not have the same set of designs unless until if those set of designs are quite the obvious one. Say, for example, a circular ring cannot be changed into different designs, but its aesthetic view or its over the ring shape, the views could be changed. So that is what we are looking at. The next one, you're seeing a chair. Chair consists of a sitting area and a leaning area. But how it is placed up, what angle, how the legs are being placed, that set of designs could be given over here. So as we know, everyone knows about the sports cars. So every sports car is of an individual design. So if morely girls could say that like the different types of slippers what they are using, different set of heels that is being into production, like sneakers, how the product is differentiated. Say Woodland, I will have a same set of a shoe, a sneaker will have a same set of a shoe, which covers your ankle, but they have a separate designs, a separate materials being utilized over there. So these are the various design aspects where its aesthetic value is increased based on the design aspect. So we would have seen trademark, right? So I think most of the companies over here known by, or if you would have come into a place because Yahoo, it's a mail ID which we have seen. Adidas, a company which is more known. BMW, Coca-Cola, Honda, McDonald's. We are seeing more McDonald's like these days. So Pepsi, Puma, Google. I think everyone goes to Google and search like the Google shape and the color. They have the same. IBM, HP. So these are the trademarks. So if there is a CNN, there is Shell over here. So NFL is there, Starbucks, Harley Davidson. But these are just few examples what we are saying. There are many more examples. Just if you take automobile alone, there will be a numerous set of designs or trade logos of that. If you say take up any other products like mobile phones, there are a lot of mobile phones with different aspects or different things. Say for example, Apple, we have seen then Oppo, Vivo, the way they have written, the way the font is being used, those are known as the trademarks. So next one, what you're going to see is like uh, it's the term of the copyrights. So we have seen the copyrights, but more importantly, the term of copyrights is quite important. So if I say the term of copyrights, the copyright is mostly given for the life of the author. So the life of the author is like the morely estimated for like 50 years or something. So from the life of author, uh, 60 years is given. This is for India. So most of the countries will be giving 50 years. So if I say USA and Europe, all they give 70 years. That is, a copyright is a product which is more than a century, I could say. Say a person who's going to invent a copyright at the age of 35. So if normal, if I put in a normal lifespan, like for 50 years, we will own the copyright. So after the life of the author, that is life of the author is like the person who has filed. We in India we give another 60 years. That's more or less give or take 100 plus years. So that is the term of copyrights which are being used. So whenever you're going to copyright something, it is going to be there for nearly a century. You can even put it like that also. Right. So, when you look for geographical indications like Basmati rice, Darjeeling tea, see the words which are put in. So, Darjeeling tea, that is like a tea produced from the Darjeeling, which has its own flavor and everything. So, many people would have come from Kanjipuram, right? So, Kanjipuram sweet style is one of the things. Alfonso mango, Nagpur orange, Kolpuri chapel, uh, Bikaner Bhuja, Agra pepper. So, that is like there are exclusive products from exclusive places, which could be taken as a geographical indicator, but you have to file that also and make sure that it is not produced anywhere. So, like as we know, Tirunelveli Halwa. So, as we said in the before, itself, it's a geographical indicator. So, just like that, we cannot replicate their names, or just like that, we cannot replicate the entire product itself because of their indications. So, geographical indications is quite important for a country to know its history and all. So the people are looking into these more aspects also. So what are you gonna do now? It's like we're gonna see some. role of the IPR in automotive industry, because automotive is right now currently growing at a very fast rate, because we are in a change of from a petrol engine, diesel engine to an EV vehicle. So there are more trends in automotive industries which we can look into it. So one is AI integrated vehicles, ancillary vehicle systems, electric vehicles, which is morely concentrated with the batteries, because right now everyone knows about lithium ion batteries. There is a company, a startup company in Chennai. They are trying to, they are trying to bring in sodium ion batteries. So that is a new way of inventing the batteries in the same way as a lithium ion battery. To have the same set of efficiency, and sodium is more abundantly available to us. So next one is the vehicle controlling safety system and GPS. So these are the new trends in automotive industries where IPR is being filed up at a very higher rate. So if you see, top patent holders for ancillary vehicle systems are like Ford, Toyota, So they are patented in more than 50. So the Robert Bosch, from the Robert Bosch to the Ford, nearly 50 patents are filed to up to approximately 320 patents, I guess. So every company is seeking to work on these set of different ancillary vehicle systems, such as it could be an electronic component, like say, for example, BS6 has come in. So what is the BS6 main aspect in this particular year? What we can see is headlights, which is being completely on switched on all the time. So the headlight has been changed into different designs. So the light is not switched on exactly, rather than subliminary light is switched on. Then in bikes and all, the stand, with the stand is on, the bike is when you put the first gear on, it will switch off. So that's those are the things which is being done with BS6. Especially these are visually we can see that, but the catalytic converter was the actual one which is being inverted for the BS6, which is of more into use for reducing the pollution. So if you see, the next thing is like the automotive association. So various things you can see. This group globe specifies the implementation of connectivity standards. So standards is like right now we have not seen in India more of that. But if you see it abroad and other uh, high branded vehicles, connectivity is given as a form of a basic standard requirement in a vehicle. Say it could be an assistance for during an incident or an accident or anything which is required, which is connected on a 24 hours basis where you can in touch with the companies itself so that you are connected in 24 by 7 during your travel. So that they are increasing the standards in that set of ways. That is like they are going to state like we have seen indications of form or your speed things and all. So the future holds is more so that like the pollution systems, how the car should be acting when you are driving on a curve and all. So that those are the things what makes it more efficient. So vehicle safety system is nothing but a collision warning brake support, which as everyone has seen, NG car has been introducing with their advertisement itself. That is, when it is about to hit a vehicle in front of it, automatically the brake is been applied to come to a stop. So it comes to a dead stop, right? So those are the things which is being effectively done. So yeah, this is an example where Ford has given this example. So collision warning is given through the radar detection, and brake support is given for despite the warning when you are moving at a collision phase. So it increases the braking. Right? So this is a easy example to understand. That is warning plus brake assistant is given. Higher danger of collision, warning plus automatic brake first stage is given. Then at the very third stage, when the space is very less, warning plus strong automatic brake is given so that you come to a dead stop. This was actually given as an advertisement for the NG car, I guess. If I would have seen removing it, you would have understand that. The MK car is like putting that it has an AI system so that it detects collision and applies the brakes so that the collision is avoided. So that was one key feature for the marketing over there. So how these things would have come into existence? These are not these are not the cases just produced by the car companies. Because car companies have R&Ds, which in turn takes up new people into places where they put their ideas into IPL, or the students who are there doing projects in their PGs or in their UGs, where they bring in different ideas into a light system. Those things are converted into IPL. Say, for example, one of our students, positive student from mechanical, have created worked on as a project with Saint Gobain, where he has developed a process which is being currently implemented in all of the Saint Gobain's manufacturing plant. The step is not taken by just by one person from a company. It is taken by students who are passed out right now, who are because students are more visionaries than the person who works in the companies, because their visions is being narrowed down. If you take up any student vision, they are were very wide and tough, right? So these are the roles of IPR in automotive industry. One is the most important thing is like vehicle controlling system, that is with ESP and without ESP. So if you see a car which is about to have a cut and go, where the electronic stability program will help us to be in track, or else this would lead us to be uh, a skidding one. So without ESP, the yellow color. So with ESP, it is marked in the black color. So you can see the difference, right? How it is being programmed. So in order to make a stability for a car, either it has to be with acceleration or with respect to uh, braking with regular intervals. That is how you control a car or any moving object. So with the help of programming, they have developed that also. So next thing what you're going to see is a quite important one. So with all these respects, we have to know what is the trend in India for IP application filing trends. So if you see the trend, trademarks is always having the higher potential because why? Because it's quite bring in a new design. Uh, it could be patent search, could be put as a trademark symbol. If you just go to Google and type trademark design, there are a lot of companies where they bring up new designs and they put a trademark value for that and they sell you the design for you. So it is a type of a business which is not directly to the customer but to a company OEM. So that is trademark trend in India. So if you see the next one is in orange color, the patterns have been given. So if you see patterns every year from 14 to 17, there is a quite increase to 11,000, 46,000 patterns. But from 42 to 46, it's a very marginal increase only. So the next one, what you're going to see is like the design patterns, which is increased from 8,000 to nearly 12,000. So when we compare these two to trademark, which is low for our pixel, right? So that is why government is being in continuously giving us concessions, incubation centers where you can uh, uh, use a trial and error method to develop your product or your process, and you can patent it up so that our GDP growth will be increased, right? So the next thing is like the trends in IPR. So how much growth we have gone from filing to grants is like grants have gone 5 times the growth have been done. So grants are given in the orange color line from here to 5,978 to 30,074. That is a huge growth. So 5 times it has really grown until the last year 2022. So if you see the patents growth, it's from 42,000 to 66,000 in a span of 5 to 7 years. So in the which we have seen in the before, it was quite low. But when you see in the growth to the current session, it is in a constant move at growth because our government, our people are putting in lot of incubation centers, which is given by the government's uh, support, so that many entrepreneurs, many people can develop their products with the help of these facilities. So one other thing is this was given by a GS code data story. So how the IPRs is in India. So total number of patents filed in 1920 shows an increase of 11%. So the important thing is what we are seeing. Please kindly note this map. Tamil Nadu stands at the second place of filing more patents in 1920. So we are actually at the very starting stage only because the numbers are actually less. But in that, Tamil Nadu is being stated as the second. On the whole, together, if I put it like in India, how many patents means? When compared to other states, we are at ninth place from other supreme countries right now. So for current data, we have to keep on improving new products, new set of designs, new trademarks, new copyrights have to come from our places so that we increase our growth so that India stands at a different places. Why we have to state this? So from the latest scoring board, India ranked 40th in 2020, scoring a 38.4 out of 100 in 50 intellectual property related indicators. That is, India scored a minimal of 38.4. So if we take other countries like Europe, USA, Taiwan, Thailand, Portuguese, Portugal, Russia, and Germany, and all, they stand an average of seven in the form of 70 there. So India has to move along a more percentage because we are scoring 38.4 is pretty less. So India's overall score increased from 36 to 38. That is 16.222 to 19.23, which is out of 50, which is not even 50%, which is in the according to the 8th edition. So according to the report, India has shown a real improvement over the past few years, adding that it has made a string of positive efforts that have resulted in a score increase. But increase is there, but it is not efficiently done. So India has registered the second highest growth over 9 edition of the US Chamber Index among the BRICS nation, with an overall improvement of over 13%. We are showing improvement in these years, that is before and after the COVID system. There is a huge, humongous increase, but the increase is huge. But we have to maintain that percentage over the years so that we uh, stand among the best in the future, right? So why IPR is important? Why these things is it directly uh, in line with the India's improvements itself. So that every new product, whatever products it's coming, before and all, we have to put from our own pocket and we have to develop the entire system or the process. Right now, there are a lot of incubation centers, which is not only open for students, which is open for any industrial person or an academician or any researcher, so that they can put their effort to building their own startup and get our country move ahead with the other countries and all, right? So I hope this session was helpful to you. So with this, I'll be closing my session. Uh, Thank you. So if there is any questions or any queries, uh, I'll be able to answer
Thank
them.
you, sir. Thank you. Thank you, sir.
Thank you.
Dear students and faculty members, um, any questions you may ask related to IPR, you may ask, sir.
So I hope there is no questions. So I guess like people could take it more in. So kindly
Uh,
look into it
I have
if there is
one
any.
question,
Yes,
sir.
sir.
Am I audible, sir?
Yes, sir. Yes, sir.
Sir, each state we will have the IPR office, intellectual
Yes, sir.
property office. Yes, sir. For example,
Yes, sir.
in Tamil Nadu, we have Chennai, Gindi area,
Yes,
we
sir.
have
Yes, sir.
the IPR office. So we suppose the patents, copyrights, design patents, like that we have the various uh, divisions are there. So, like for all the copyrights and design, everything we can approach this patent office or some Kolkata, like that. We will. What type of patent we have to approach
Sir,
that Kolkata
yes, sir.
chapter?
Yes, sir.
Kindly clarify, sir.
Before, sir, uh, uh, by the organization structure, certain things like patents means only five places among the entire India was able to patent up. And for the copyright platforms, there are other set of states. But right now, what they have done is you can file your entire thing, whatever you are trying to patent up, you can do it online itself. That is why they have given the website. So it is
Oh,
the
okay.
where you can select whether as a patent or it is a copyright or it's a trademark. There is an option to choose and download those forms because they will be giving the entire form structure itself with detailed explanation. So whichever necessary forms alone we can download, we can fill it up, we can upload them online itself. So everything can be done online itself. So it is an effective way that they have given so that we don't have to travel along for filing the patent alone. So that was one big step for us so that more patents can be filed without moving from one place to another.
Yes, sir. Thank you. Thank
Yes,
you,
sir.
sir. Thank you.
Thank you, sir. Thank you very
Okay.
much.
Dear students, any other questions from your end, faculty members? Okay. Thank you, sir. Thank you. Now I request Vignesh, IAC student member, to deliver a vote of thanks.
On behalf of IICSPC Sri Perumbudur, I would like to take this moment to thank Mr. M. Nishal, the distinguished speaker of this event. Thank you, sir. I'd also like to thank all the student members and faculty coordinators. Now I request all the participants to fill the G form posted in the chat box to claim their participation certificate.
Thank you, Vignesh. Thank you, sir. Behalf of IAC, we thank our speaker, Nishal sir. Thank you, sir.
Thank you. Thank you, sir. Thank you very much.
Dear students, please, we posted the feedback form. Kindly fill that form.
Sir Nadarajan, sir, am I
Yes,
audible?
yes, madam.
Okay, sir. Now the session is too good. Thank you, sir.
Thank you, madam.